candidate who also polled 17,206 votes. With this declaration, the NDC, they were not happy with the declaration. They were not happy with the entire election. So, led by Akwatia Annan, the NDC rejected the results. They cited irregularities in the election process. I will show you a video on our social media platform. So join us there, 3FM 927. Video of the dispute, if you like, the chaos that marked the declaration process and, was a benchmark for the NDC's position to dispute the election result. From 10th to 15th, this happened. Due to the disagreements, the Akwatia results were finalized in Accra instead of the Eastern region. Although there was a declaration made that the MPP candidate won, and I'm talking about the Akwatia Member of Parliament, Ernest Yakumi, there were a lot of disagreements, and then it had to happen in Accra instead of the Eastern region. The NDC's case was that NPP lacks original pink sheets. The NPP was relying on photocopies for this collation that declared the Member of Parliament for Akwatia, Ernest Yakumi, to have won the election. So the NDC candidate, Akwatia Annan, he filed a petition. What he was doing was seeking an injunction against the swearing in of Ernest Yakumi, the elected Member of Parliament for the area, and that happened on December 20. So January 2, the Koforidua High Court, they granted a 10-day injunction barring the EC and the Clerk of Parliament from recognizing Kumi as the Member of Parliament elect. That was on the 2nd of January 2025. Mind you, the swearing in of these MPs, the newly elected members of Parliament, that was on the 7th of January 2025. Ernest Yakumi was in Parliament on that day, the 7th of January, despite the injunction, the 10-day injunction period from January 2. He was sworn in despite the injunction, meaning that he chose to face any legal consequences. When that happened, the Clerk of Parliament, Mr. Akwatia, before the Speaker was elected, if you like, and before these new members of Parliament were sworn in, Akwatia had some words of caution for the members of Parliament, particularly for Ernest Yakumi, particularly for the minority in Parliament. Let's listen to what the Clerk of Parliament said in relation to the swearing in of Ernest Yakumi in the face of an injunction. And mind you, the injunction was to the EC as well as the Clerk of Parliament, which happens to be the man whose voice you're hearing now.
In the case of Akwatia, the Clerk to Parliament was served a process on the 3rd of January 2025 with an order of interim injunction from a high court in Koforidua. This order was served through the legal office of the Parliamentary Service. The order directed the respondents, including the Clerk to Parliament, indicating that they are restrained from proceeding to call, admit, register, swear in, recognize, gazette the said Ernest Yakumi as the elected member for the Akwatia constituency. At the time of the receipt of the order, the Parliamentary Service had already completed the process of registration of Ernest Yakumi as member-elect. Honorable members, so I have brought this matter to the attention of the House. That is my pleasant duty to do. The member may decide, may elect to participate, but in doing so, I'm drawing attention to Article 105 of the Constitution, and I will read, a person who sits or votes in Parliament knowing or having reasonable grounds for knowing that he is not entitled to do so commits an offense and shall be liable on conviction to such penalty as shall be prescribed by or under an enactment of Parliament. Having done this, I have discharge my noble duty. I'll end there.
Mr. Chairman, the member so desires to proceed to be sworn in and to also participate in the election of the speaker and bear the consequences himself.
So that was the Clerk of Parliament speaking first, and then was the Minority Leader, Alexander Penyo-Markin. And then Alexander Penyo-Markin said the member so desires that he continues with the process, bearing in mind the consequences that may come afterwards. So then came yesterday, fast forward, February 19, 2025. An arrest warrant was issued by the Koforidua High Court for Ernest Kumi's arrest for contempt of court, because the court said for 10 days, don't go there, don't go and be sworn in, don't carry yourself as a member of parliament, but he did. And then this arrest warrant was issued. Mind you, Ernest Kumi was in Parliament yesterday. He spent about 30 seconds there. Oh yes, we
were counting.
Oh yes, we saw it. He went to put, that was before proceedings began. So that's the video of Ernest Kumi. He seated in Parliament there, and then just after a few seconds, we saw him come out. So that's his. After that, we saw him in a meeting with the leadership of the party. We see Penyo-Markin there. We see the Deputy Minority Leader, Patricia PJ, there, with Ernest Kumi, of course.
Leadership of the caucus.
Leadership of the Minority caucus in Parliament. The video you're seeing right now on our social media platform is also that of his lawyer in the Eastern region, the High Court issuing the arrest warrant for his arrest due to, if you like, his position to go back to Parliament even yesterday and before yesterday. I'm talking about the 7th of January. Sisters, the question on the minds of many was this expected?
Yes, it was, because you know, this was part of the controversy we witnessed that night. It was, his seat was among the disputed seats.
Exactly.
So that and Ablekuma North. And till now, we still don't have results for Ablekuma North, right?
Yes.
And so it was necessary for the clerk to have issued that disclaimer. And we saw leader of the caucus also giving the assurances that the member understood fully well what the implications were of the action that he had taken that night. And so, yes, that was to be expected. Also because the case was still pending and is still pending before the court. That case it's a case of an election petition. And so, again, yes, we're expecting that this was a likely outcome of the application that had been brought before the court for him to be, they should pull his ears more for disobeying the court and disregarding the court. And so, yes, but outside of the legalities, Crosby, could this matter have been managed?
It certainly could have been managed
between
better.
The NDC and the MPP, the two caucuses. Could they have seen eye to eye on this matter? Can they see eye to eye on Ablekuma North? Because till now, we are not seeing any end in sight for the case of Ablekuma North. So just imagine that Erabna Oben, right, of the NDC, right?
Right.
Had also gone to be sworn in, because at that time she was the one who had been declared
winner by the EC officials there.
So imagine she had also gone to be sworn in. would we have still been where we are? There are two contested seats. Let's share. NDC take one, MPP take one.
Well, that's not how it works. It couldn't have worked like that.
No, but I'm sure that, and I have said it here before, that between the NDC and the MPP, they know who won which seats.
Of course.
They know. But because of the investments that have been made into the election, financial investment, emotional investment, Charlie, you are seeing the seat, you are seeing it, but something is pulling
it back. Yeah.
Said, no, this I have to force more. Tema West, we spoke to Ibi Bright, right?
Yes.
She came here, we congratulated her.
That she had won. Only for us to wake up the next day.
The next day, they had gone to collect and declare, and she had lost. That one, I'm not even sure what the status of that case is.
So, Sixers, what we're seeing on our Facebook stream right now is the disturbances that mad as part of the collation and the counting process, that people were not happy. They thought there were a lot of irregularities in the counting process because the MPP candidates, the NDC say, the MPP did not have the original pink sheets. They were relying on photocopies. So this is why the Akwatia collation had to come to the Greater Accra region for it to be done at the old EC head office, the original office of the electoral commission. We'll be speaking with Yvonne Nikwe shortly. He will tell us how the case has traveled so far, and then we'll get to know the position of the minority caucus in Parliament after the arrest warrant was issued yesterday and after their member was spotted in Parliament yesterday. Howbeit, just a few minutes. Yvonne, good to have you on the lines. Thank you so much for joining us. This is something you've been following for a while now. Yesterday, the court issued the arrest warrant for Ernest Yao Kumi. Talk to us first for residents in Akwatia. How are they responding to this development?
Good morning, Crosby, and good morning to our listeners. Now, for the residents in Akwatia, it's been a mixed feeling for them. Of course, it's a sharp divided constituency because of the situation of elections as to back and forth on who wins that constituency. Some believe that indeed he has flouted the orders of the court and needs to be dealt with. Others felt that, well, the EC has declared him as MP for that area. He should be left to continue his work. And so for those constituencies, that has been the feeling and reaction from them since the news broadcast for his bench warrant yesterday.
But talk to us, what happened in court yesterday as well?
Okay, so yesterday in court, when the case was called, the MPP lawyer for Ernest Yao Kumi, Davis Nimako Mafo, rose to, as the word, make a case or possibly pass information to the High Court judge, but he was denied. The judge, just his lordship, Justice Senior Ameda, says he will not record him because he had not officially made a case to appear for the case, and so he did not see why he should be allowed to actually make a case or even put information through. So we have went ahead to actually read as the cases had unfolded. The NDC guys had placed in the interim injunction and was upheld by the court. When the MPP was also denied their case to squash that interim injunction for him, Ernest Kumi, to be still the MP as the actual election case be determined. And so the judge said that since Ernest Kumi had flouted his orders by availing himself in court to be sworn in, especially when the clerk of parliament had cautioned him and said that the consequences thereof, he needs to bear them, him accepting it, and the authorities, he also cited other cases that had occurred before, he feels that the MP, as declared by the EC and Yao Kumi, did disobeyed the court, and so a bench warrant for his arrest is the case and not brought to the court for a sentence of conviction. Now, the NDC counsel, lawyer Bernard Bediako-Bede, says, well, it's in order what the court had said, because their interim injunction, as it were, was in the right direction. And so for them, it was a happy moment for them, what transpired in court yesterday. But it was actually a case of reflection for the NPP side. A handful of them, including lawyer Gary Nimanko, who turned up in court yesterday, did not want to speak on the ruling.
We understand the judge, Justice Senyo, he also held that the convict, throughout the hearing process, failed to appear in court in person. Was there a time that he ever was in court? And I'm talking about the Akwatia MP.
Exactly so. So right after the High Court upheld the interim injunction of the DC, that was the last time the MP and the lawyer was in court. I'm referring to the case since after the December election. And so that was the last time we saw him in court. Subsequently, he was not found in court, neither his lawyer, Gary Nimanko. Now, let me make this point as well. Yesterday, his lordship, Justice Senyo, actually said that there was a letter for the minority caucus pleading that the MP actually had parliamentary business, reason why he was not availing himself. But his lordship, Justice Senyo, said that he couldn't agree with the letter because it would contradict his earlier decision, which says that he should not be allowed or probably be called an MP for the area until the determination of the court. And so that particular letter was not recorded for the court purposes. And so this is what transpired in court yesterday.
So going forward, you already spoke to us about what the reaction of the residents has been. But going forward, for supporters of the NPP there in the Akwatia constituency, what would they want to see happen?
Well, for them who are solidly behind NS Yakumi, the whole would be for him to continue to be their MP of the electoral commission. That's the commission hoping.
Yvonne, unfortunately, you were breaking up at a point. Could you make your point again?
Yes, I'm saying that for those constituents who are staunch NPP, they're hoping that justice is given to the MP for him to continue his MPship as declared by the Electoral Commission. They believe that as the Electoral Commission has declared him, he is supposed to be the MP and run the constituency for the next 4 years. But yes, there's the court ruling. We'll see how it turns out, how everything unfolds as well. We do know that, as I said earlier on, there's a sharp crisis there where the NDC believes that it also has a case. 4 years ago, the NDC was in power for that constituency. Okoye was the MP. Now the seat has turned back to the MPP after the Amase era. So it's a constituency to watch from today till as the court cases continue to unfold. Let's see what the police and everybody who is mandated to work do.
Yvonne, thank you. Thank you so much for your time with us on the program. Yvonne Nikwe is our Eastern Regional correspondent speaking with us there. Let's now take a listen to what the residents of the Akwatia constituency are saying in relation to the development about their Member of Parliament.
Parliament because we are ordered that to say to my I'm gonna for my dream check. I same way want to say court. I say not say MP. Mr. NX for me when to me and give brandness why now won't find say because say it will not set a good example for the other MPs to follow.
Madam, I just an committee, so much. It says, "What Nasabra? Nas, court, man, I want to show you on number 4."
So the residents, they are divided over the happenings, whether Ernest Yakumi should be arrested and whether or not he should be allowed to carry out his duties as a...
They are divided. They are NDC MPP.
Of course, supporters of him.
They are NDC MPP, so that's what we expect. That's what we expect.
Well, the minority leader, Alexander Payne-Marking, he's not too happy. You understand? They're not happy about the High Court's decision to convict the MP for contempt of court.
There was, yes, whether you have legal representation or not, the court is expected to do right and just by you.
Right.
So you, Crosby, when we arrest you...
Use Abiam.
when we arrest you and take you to court.
When they arrest Abiam.
You are even lucky we are taking you to court.
You know, not to catch your sisters, but growing up, if you go to Sunday school and they are doing play, and you come and tell us, they are going to do play, they will ask you, so the play, what part are you playing? If they say you are devil, my mother will say, no, my son cannot go and do that. But talk to us.
Why? She didn't understand that it was just play.
Sure, I got to... When they arrest me, I make your point.
So when we arrest you, Crosby, and take you to court,
I jump and pass.
What are you fighting?
Use Abiam. Abiam is not objecting to the thing.
So at the point of arrest, they would normally tell you that you have the right to this. You have this. You have the right to lawyer. If you don't have, you provided. Okay, so case has started. You don't have a lawyer,
right?
But the court is still under obligation. There's a duty on the court to ensure fairness,
right?
To ensure that your rights are protected, whether you have a lawyer with you or not. Okay, so. Well, that's the point. I was going to make the point about Mr. Kumi not having or Mr. Gary Nimako not representing the Honorable Kumi up until yesterday.
Kumi was represented in court throughout, but he was not present in court. That's what the judge said.
No. What Yvonne told us is that Gary was in court, but not as lawyer of...
Okay, you mean for the event yesterday?
For the event yesterday. In fact, I understand the report as I have followed it indicates that Gary has been appearing in court, but not as lawyer for Mr. Kumi. Yes. So...
But he doesn't have lawyers when he goes to court?
He definitely would have.
Okay.
Which is the point I'm coming to make.
Right.
That the minority seem to have suddenly taken up the matter after this. I don't know the backroom work that has been done. I don't know the engagement. You know, I was talking about engaging on these matters, how to deal with it so that it doesn't escalate, prolong, and keep the constituents out of, deprive them of representation in Parliament.
Right.
Okay. So if Mr. Nimako was in court, he couldn't have traveled all the way from Accra to Kufreja just to sit down and watch. He would have been there in a certain capacity, and he wasn't representing Mr. Ernest Kumi or Honorable Ernest Kumi.
Right.
Up to the point that there was the need for a critical intervention, then he attempted providing the court with information, as our reporter said, and the court declined to hear him. Now, there are two things here. You are either lawyer on the record to speak on a matter, or you are speaking as a friend of the court. So the other thing that would have to seek clarity on would be why he was denied the opportunity to speak, even as a friend of the court. That bit was not clear from the report that we have heard. But I think that the minority could have handled this matter and stopped it from getting to this point. It would appear that the caucus is now doing firefighting, which
maybe
is
too late, eh?
A little too late.
Well, let's speak with a lawyer on the back of the happenings. Osman Al Hassan is a private legal practitioner, and this is a subject he has also followed. Counsel, good morning to you.
Good morning, and good morning to your listeners.
This is a rather unfolding event that a lot of people say they saw coming. From where you sit, did you also see it coming up until this point?
Can you take the question again, please?
Right. What I'm asking is, you've seen how the case has traveled since December 8th, from the counting and the collation of the results up until the injunction application by the court to the EC and the Clerk of Parliament, making it known to Ernest Yakomi that this is what he's getting himself into if he decides to be sworn in, Ernest Yakomi going ahead to be sworn in and all of that. Did you see the case traveling up until this point that an arrest warrant has been issued for Ernest Yakomi?
Well, I would say yes and no. Yes, because as a matter of course, if you disobey court orders, this is what it will result in. So as a matter of law and as a matter of course, that is what should be expected. But I don't have any reason to have expected that an honorable member of our parliament will be the subject of that legal disobedience and the enforcement of such a court order. Since he undertook to go against the court orders, I expect him to be able to go and answer the court why he decided to do what he did. Because if there's a court order restraining you from doing something or enjoining you from doing something, and you disobey the court order, what is ordinary? What is the necessary effect is that the aggrieved party will hold you to contempt of court, or the court itself can hold you for contempt of court. So but contempt of court actually is a conduct you have put across that undermines the administration of justice, or that brings the administration of justice into disrepute. And so sometimes it can happen without a court order, and it can happen with a court order. And that's why we have infashi and exfashi Korea. I don't want to go into all that. But the point is, once there's an order and you have done something contrary to it, you will expect that the court will hold you to contempt. And contempt is when you do so willfully. You see, I talk about bringing the administration of justice into disrepute or undermining it.
Right.
But what is necessary to that conduct to make it contempt is when it is willful. So when you willfully undermine the court or willfully bring the administration of justice into disrepute, you need to answer. And that's why sometimes when you are summoned to the court for contempt of court, the summons tells you to come and answer why, or to come and show cause why you should not be held for contempt. For it means that what it means is that the actus reus, the facts that give rise to contempt of court, have probably been established. Now they want the intention, and that intention can be gathered from questioning you. So when you are summoned for contempt, you have to be there personally, then with a lawyer to defend you.
Right.
So that they will be able to, court will be able to establish whether your violation of the court order was willful or otherwise. Because if you send a lawyer to the court without yourself to go and represent you in court in matters of contempt, they will not be able to establish the willfulness of your conduct from your lawyer. And you see, when you have been given an opportunity to be heard, we know that the opportunity to be heard is very fundamental to every judicial process, and without it, the judicial process may come to naught. And if there's an order, it might be nullity. But the opportunity to be heard doesn't mean that when you are not there for whatever reason, then the opportunity to be heard is denied. No, if you are giving a notice to be before the court and you decide not to appear to be heard, the court can go ahead to deal with the matters without you. And if you look at our rate of summons on forms, it is always issued by the chief judge. And you see at the end of it, they will tell you that upon the service, if you refuse to appear for the hearing, the court will proceed without any further notice to you. So it means the opportunity to hear can be given, but it is up to the party to exercise it or not. And if you don't exercise it, you can't raise it again as a matter that goes against whatever proceedings the court had engaged in. So for me, as your question, I didn't expect that after doing what he did, he will not be willing to present himself to the court to explain. Perhaps that's what we call purge of contempt. Perhaps you'll be able to purge your contempt by saying that it wasn't willful, it was due because of ABC.
Right.
So, but if you fail to do that, and I think that's what has happened here, and that's why I said I didn't expect it to happen, because this is a member of parliament, and so we hold members of parliament in high regard, and they are the makers of the law. So we least expect them to be the ones breaking the law and violating court orders, because without court, there will be no democracy. Without democracy, members of parliament have no job.
Okay. Lawyer Hassan, when an arrest warrant is issued, what does it mean? And in this case, what does it mean for Ernest Yakumi?
No, an arrest warrant is basically a permission to a law enforcement officer or any individual to effect an arrest of a person who is alleged to be an offender of the law. There are circumstances you can arrest with or without warrant, but I don't think that's what we want to take the public through now. But the point is that at the instances where it is appropriate for an arrest to be effected with warrant and the warrant is issued, what it means is that the person should be arrested according to the warrants of the court and brought to the court to answer whatever charges the court has before it.
The minority in Parliament, although they are unhappy with the court ruling, they say that they are sure necessary steps will be taken to ensure that their colleague is law-abiding and that the right thing is done, although they are dissatisfied with the approach and they think that he has been treated unfairly. When we say the right thing should be done and they will take all the necessary steps to ensure their colleague is law-abiding, what could it possibly mean?
This is an acknowledgement that their colleague is not law-abiding, if you ask me. Because if the minority leader has to take steps to make an adult who is capable of knowledge of the effect of his own conduct and is educated, and on top of that, he's of parliament, and they need a leader of the minority in parliament to take steps to ensure he's law-abiding, that tells me that they know that he's not law-abiding.
I see.
And so, but the steps they are going to take to ensure that he's law-abiding, to me, to be honest with you, is so vague. I don't understand what that means. It could either be an advice to him, it could either be some form of compromise being reached between maybe him and the other party. It sounds a little vague. The only thing they can do is advise him, give him legal advice, and give him a lawyer, if he doesn't have one, to accompany him to the court under the circumstance. Otherwise, I don't see what they mean by ensuring that he's law-abiding. That's not the job of the minority.
Right.
To ensure that someone is law-abiding is the job of the priest. Yes, so when we are all supposed to be law-abiding,
right,
and if we are not, we are compelled to do so. It is not our own discretion to be law-abiding. But if the minority wants to take that, well, that can only be advisory. I don't see anything beyond that.
Counsel, finally, where do we go from here? How do we ensure that a certain right thing is done?
Well, if a warrant has been issued for your arrest and you don't want to be arrested, you simply submit yourself to the court or to the authority before whom the warrant is to be taking you to. So if the court issues a warrant for your arrest and you don't want to be arrested, you just present yourself. But if he decides not to, which is a discretion he might exercise, remember, everybody can exercise a discretion positively or negatively. So if you can decide to exercise your discretion not to obey the law. But of course, the consequence will not be your discretion. The consequence will not be your discretion. If he decides not to submit himself, of course, the warrant that was issued would be enforced. It would be enforced. Though he might have some parliamentary privileges, there are ways to navigate them in the legal proceedings. So that will be done, and that should be done.
Osman Al-Hassan, thank you so much for your time with us on the program. Osman Al-Hassan is a private legal practitioner speaking with us there. Let's now get onto the phone line still and speak with Sami Obeng from the African Parliamentary Network there. Sami, good to have you on the lines. Thank you so much for joining us. This is where we find ourselves. An arrest warrant has been issued for the arrest of a member of parliament because he has been cited for contempt of court. And we know how the case has progressed up until now. What does this mean in parliamentary parlance?
Well, good morning to you and your listeners. We have a member of parliament who has been duly sworn in parliament. Prior to his swearing in, the implications of what could go wrong were made known to him. And speaking through the leader of his caucus, he elected to go ahead and face the consequences thereof, if any, because the Clerk of Parliament, as you have already read out the provisions of, I think, Article 105, which speaks of the Constitution. So we are talking about the Constitution, you're not even the standing orders of Parliament, which speaks to what happens if you sit, vote, participate in a parliamentary proceedings knowing that you are not supposed to. Parliament went ahead to swear him in, and he's a member of Parliament serving the people of Akwatia. The courts have issued a warrant for his arrest. We also know that now that he's a member of Parliament, the rules relating to parliamentary privileges and immunities applies, which means that he cannot just be, arrested, so to speak. Fortunately for us, there is a tidier arrangement between the judiciary and the legislature on how to effect the arrest or how to, deal with members of Parliament when they are facing some of these issues in court. The Speaker has spoken extensively to it. The judiciary, through the Chief Justice, has issued some administrative directives in relation to that. And so we'll expect that they would go through that particular process. He would subject himself to the court for the sentencing that needs to follow the conviction to happen. These are all processes that are steeped in law. The Honourable Member of Parliament was aware of these, and because of that, I'm sure that he and his lawyers, together with leaders of his caucus, will be looking forward to going through the process as it is. And for us, it serves a very important standard based on what happens with this particular case, on how we proceed as a country, on election of members of parliament and swearing in. Because if the chronology of events is anything to go by, we know then that in subsequent parliamentary elections, it's very likely that such things will happen. And depending on how this particular case gets treated, we will now have members of parliament elect and their caucus leaders being either cautious on the decisions they take on the 9th of swearing in, or perhaps, leaving it to chance, citing this particular case as a precedent. Because what is the chronology of events? Elections take place. Electoral Commission declares a particular candidate as having won. The Constitution is clear that if you want to challenge the election of somebody as a member of parliament, you go to the High Court. So the other party goes to the High Court. They only do not go to the High Court on application, but they also ask the High Court to injunct the person declared as having won from holding himself. The person comes to the High Court proud to the swearing in to say, I want to challenge this. The High Court says, no, we are affirming our position on the matter. And this only happened on the 6th of January. The High Court affirmed it. He decides that, well, despite the High Court's decision affirming this the afternoon of the 6th, I will still go to Parliament later that night to be sworn in. Clerk of Parliament reads the relevant provisions to him, and the fact that they've been said, he says through his minority leader that, look, I'll go ahead to get sworn in and face the consequences thereof. The court says you have disobeyed us, and we will fine you for contempt of Parliament. It is important that the court, we know that the courts would like to assert its authority in matters like this, because they will not want to leave some of these things to chance. Other than that, in the future, there will be instances where people will disobey the court with blatant disregard. And so the court, in wanting to assert its authority, would want to do something about it. But for me, the most important thing is that this case, depending on how it goes, will help set out the parameters around which members of parliament who have been elected, yet their seats are being contested in court, to know how to hold themselves proud to swearing in.
The minority in parliament, they say that they will come out with their full position after they've received a full briefing from their lawyers. Talk to us about how this could have been handled differently. My colleague Sisters is making the point that both sides of the House, the majority and the minority, they could have reached a certain compromise so that we don't get here.
Well, I also hold the view that we could have not gotten here. This was avoidable. Why? Because, from a neutral, common sense position, the numbers in Parliament on the 9th of, on the early mornings of the 7th of January, would not have changed anything without him, being sworn.
True.
And his caucus would not have lost anything. The decisions that were taken on that particular morning would have stayed. Maybe the politicians knew a lot more on why this should have happened that way than we know. But sitting behind and determined. I mean, this is not a case of 7 January 2021, when you knew that just a single individual could change the entire dynamics, right? In this case, the number differences were so huge. And so just waiting a couple of days, to avoid some of these things, in my opinion, would have been the most appropriate thing. But remember that he spoke through his minority leader, who is an astute lawyer, who is the same person who yesterday granted that very short interview and said they would speak to the lawyers, get a full briefing, and they will come out appropriately on the subject matter. Hopefully they have some actions under their sleeves that they would want to put out. But this could have been completely avoided. And I think that the outcome of this process should serve as a lesson to the various political parties, the various individuals who put themselves up for elections as members of parliament going into the future, so that you don't put yourself in such an uncomfortable situation simply because you decided that you cannot wait a few more days.
Sammy, maybe finally, before you take leave of us, for the constituencies that are still in dispute, the Ablekuma North constituency, we still do not have, if you like, an MP there, and then the constituency for the Honourable Frank Anodompreh. Although this may not be the same circumstance, but are there lessons for these disputed constituencies and their member of parliaments to learn from?
For those that are in dispute because, members of parliament have been declared and others who disagree with the decision have taken it to court, remember that this is something that has been with us for a while.
Right.
And while we remain a human institution, we would have these things going on and on. At every point in time, people will challenge, and that should be fine. You go through the legal processes. If you're exonerated, you continue with your work. If you're asked to get out of parliament, like in the case of Mr. Kwesi, you get out of parliament and whatever happens following. So for me, I have no issues with that. In fact, my only concern would be the time frame, so that these challenges in the High Court do not linger on forever. Because we've had instances where, the court case goes on and on and on and on. And by the time the court will probably determine the issue, it would have been a wasted, effort, because whoever had won, if the person was not a legitimate winner in that election, would have served a full 4-year term and no justice would have been served properly, to the other person who brought the case to court. My concern is with Ablekuma North. And I think it's completely untenable, completely unacceptable that the people of Ablekuma North, with almost 2 months into a new parliamentary tenure, do not have a representative. That's tens of thousands of people who've been denied representation in parliament simply because an electoral commission and police decide that they are unable to do the work that they are mandated to do because a group of people will come mess things up. If we live in a country where tens of thousands of people will lose their rights to representation because our security forces and institutions that have been mandated to do their work cannot go ahead to do their work with the forces of the state being used to protect the sanctity of that particular process, then we are in real danger. We spoke at Parliamentary Network Africa against the fact that SAL did not have a representation in Parliament for 4 good years, and the same principle applies. We cannot have the people of Ablekuma North sit on tenterhooks and not have their representation in Parliament. What this means is that the people of Ablekuma North have not participated in the people who have become ministers of state and deputy ministers in this country. The people of Ablekuma North have not had their voices heard on the major decisions that have been taken by Parliament so far. The people of Ablekuma North have not had questions and statements that relate to their constituency put across on the floor of Parliament thus far. Right. The people of Ablekuma North have not participated in who is holding himself as Speaker and Deputy Speakers in this 9th Parliament. They've not participated in that particular process. They've been left out and will continue to be left out so long as the Electoral Commission, the police fails to do their work. And we all appear to be silent about this, allowing the politicians to play their regular politics and allowing state institutions to pass the buck and puts the blame on others rather than doing their job. This is completely unacceptable.
So, I mean, although I said finally, maybe this one is finally. The Akwatia MP, Ernest Kumi, he was in Parliament yesterday, although he spent very few minutes there. With all the happenings around him, should he still be coming to Parliament?
Well, the many lawyers have spoken about this. We've heard how matters relating to contempt needs to be dealt with so that you don't find yourself in even deeper waters. We've even seen how contempt of Parliament itself, a way of approaching it. If you are charged of contempt of Parliament, how you approach it so that your issues do not get compounded. And so to stop him from compounding his issues, it will be great for him to take steps that convinces the court that he's not willfully disrespecting the court, its decision, its authority, and what have you. And that's why, as a first instance, it was quite refreshing to note that perhaps upon getting into the chamber yesterday and the information getting to him, he decided that he would, at least if the news report is anything to go by, he would leave the chamber, not participate in the proceedings of yesterday. We don't know what's going to happen today and the days that follows, but I think, and this is based on my own understanding from what lawyers have explained, that it will be appropriate that he takes steps to convince the court that he did not set out to disrespect the court, so that he will not be in even deeper waters going forward.
Samuel Bing, we thank you.